visible. So guys, we are going for the second part. एक बार कोई भी ऑनलाइन आ जाओ. Let me share this first. Okay, so this is going to be the second guys, nobody is online but I'm going to start the class. आ जाओ जल्दी, कोई है क्या, कोई बता दो आवाज़ आ रही है क्या, अदरवाइज आई एम गोइंग टू स्टार्ट द क्लास गाइज. कोई नहीं आ रहा, सब बेकार बच्चे हैं, ठीक है. सो वी आर गोइंग फॉर द इंसॉल्वेंसी एंड बैंक्रप्सी कोड under 216. So let's go for it guys. You will get all of the PDF in my Telegram channel, and my Telegram channel link is in my YouTube bio description. Okay, so if you haven't done have notes, it's super easy and handy notes, and you will get everything in clear way. Okay, yes, one more thing, what I was talking. Okay, leave it. Let's go for the section, this chapter, which is insolvency and bankruptcy code guys. Okay, so yes, insolvency bankruptcy code, I'm in the page number 3rd. Let's go for the regulatory mechanism. Who are the regulatory mechanism as per the insolvency and bankruptcy code here? Okay, so that is two. There is two regulatory mechanism, which is insolvency and bankruptcy code of India, and second is going to be educating authority, who have a very major role in our chapter. So under the insolvency and bankruptcy code of India, there are going to be three parties. ठीक है, parties बोल देते एक बार, which is the insolvency professional agency, second insolvency professional, third is going to be the information utilities. So these are the further divided, the regulatory mechanism is further divided into three parts. Okay, so let's understand what is this financial creditor, because we are having this section which is related to financial creditor and the operational creditor. So the financial creditor means any person whom a financial debt is owned, and include a person to whom such debt has been legally assigned or transferred to. Okay, which means पैसे का खेल है. Financial creditor means पैसे वाली दिक्कत. Okay, and what about the operational creditor? Goods. Okay, which means a person who an operational debt is owned, and include any person to whom such debt has been legally assigned or transferred. So these are the two terms which we are going to use, and we should know what is actually the meaning of these two terms. Okay, so let's go for section 4, which is hi, can you hear me? Please say hi if you can hear me, and tell me whether am I audible or not. Okay, so let's go for the application of part 2 of the code section 4. This was the question in form of MCQ guys. So it shall apply to the matter relating to the insolvency and bankruptcy and liquidation of the corporate debtor, where the minimum amount of default is rupees 1 lakh. So if it is less than 1 lakh, this cannot be possible. You cannot go for insolvency and all. Okay, so with that, the central government may by notification specify the minimum amount of default of higher value which shall not exceed more than 1 crore. MCQ के फॉर्म में आ सकता है क्या मिनिमम? हाँ जी, 1 lakh. ठीक है, what about the maximum? It's going to be 1 crore, and who is going to specify? The central government is going to specify. Let's now go for the important sections guys. Section 6 is about the person who may initiate the corporate insolvency resolution process. Now who can be the party who can initiate these things? There are three parties. which one is going to be the financial creditor, second operational creditor. Now we know who are the financial creditor, operational creditor, but what about the another person? There is one more party who is the corporate debtor, which is the company itself. Yes, the company itself can also initiate this CIRP process, which is corporate insolvency resolution process. So this is about the section 6. Remember section here. So section 6 is about the person who may initiate the corporate insolvency and resolution process. Let's go for section 7, which says about the initiation of CIRP by financial creditor. So financial creditor, either by itself or on jointly with other financial creditor or on behalf of other financial creditor, can file the application. Now, to whom this financial creditor is going to file? To the adjudicating authority, which is the regulatory mechanism we already read. Hanji. And with that, but against whom? The corporate debtor. Okay, so here the financial creditor may file the application for the CIRP, corporate insolvency resolution process, against the corporate debtor before the adjudicating authority when the default has actually occurred. Default occur करने के लिए what were the minimum amount? 1 lakh and 1 crore maximum, which should not be exceeded, right? Yes, but along with that, with the application, there are some documents which is to be furnished along with this application. Okay, yes, what are that? The record of default. What is the evidence? If there is no evidence, law evidence मांगता है बाबा, ठीक है? So you have to furnish the evidence of default along with the application. Record, then what? The evidence. Third, the name of resolution professional. Okay, the financial creditor, if they have any name which they could recommend, they can for surely, and the resolution professional whose name is given by the financial creditor can be appointed in future as the interim resolution professional if there is no any proceeding is done against, any pending proceeding or case is not done against this person, the resolution professional. Then this person would be appointed as an interim resolution professional, or any other information which is specified by board. So guys, let me tell you one thing, you have to remember these thing, because question आया simple, बहुत ही simple तरीके से, whether the name is given, ठीक है, and they have mentioned that this person is a financial creditor of the company, of corporate debtor of the company. So whether this person can initiate CIRP, which is corporate insolvency resolution process, अब मैं CIRP बोलूँगी, okay? So whether this person can initiate this, yes, under section 7 they can do, the creditor, the financial creditor can do this, okay? But what are the other documents which they have to furnish? So you have to remember the documents along with this, okay? So record of the default, the evidence along with the name of resolution professional and any other information which is specified by the board. Okay, then the CIRP is going to be processed once the date of admission of application is done to the AA, okay? But here the AA can accept or reject their application, okay? Okay, so one thing I want to tell you, the CIRP, the corporate resolution process, commence from when is a question being asked in form of MCQ. So it's going to commence from the date of admission of application by the AA. So when it's going to be accepted by the AA, it's going to be commenced, the CIRP is going to commence. So this was in form of MCQ. So let's go for the application. Adjudicating authority, they can accept this application along with the document furnished by the financial creditor, or they can reject it. But within how many days? They are going to accept within 14 days of receipt of such application if it is satisfied. If it is satisfied or what? If it is satisfied that the default has actually occurred, okay, and the application for initiating the CIRP is complete. CIRP, yes, it is complete. And third, no disciplinary proceeding are pending against the proposed resolution professional. Again, I'm saying you have to remember these things, because same thing is in section 8, same thing is in section 9, same thing is section 10. 8 में नहीं है, बस थोड़ा सा, ठीक है? So you have to remember this point, because 9, 10 में भी same चीज़ है. So please try to remember this, ठीक है? Okay. So A, they can accept that the application, or they can reject that application. Accept करेंगे कब? Default has actually occurred, ठीक है? Okay, with that the application is complete for the CIRP process, actually is completed, okay? And third, that there is no disciplinary the proceeding against the resolution professional, the name which is proposed or given by the financial creditor, okay? And when they can reject, they have some whatever the condition which I already told you, ki default has occurred, the name and all, okay? If anything is not done, like the default has not occurred, so the A is not going to accept the application of financial creditor, that's it. And what if the application for initiating corporate insolvency process it's not complete, again A is not going to accept that application. And last, what if the disciplinary proceeding is actually against the proposed resolution professional, then again the simple baat hai ki the A is not going to accept that application, okay, of the financial creditor. But before rejecting the application, the AA shall give a notice to the application to rectify within 7 days the defect in his application. Okay, so A is going to give the opportunity to you have to rectify if you within that 7 days of application. Okay, this was all about this section 7. You have to write each and everything when you are writing the answers, guys. Okay, let's go for section 8, which is of the insolvency resolution by whom? By the operational creditor. Now here earlier was of section 7 was of financial creditor. Section 8 is going to be of the operational creditor. With what are the things the operational creditor going to give along with the copy of invoice? I mean, there is something which the corporate debtor is, what is this corporate debtor within? Let me tell you one thing again. Okay, operational creditor have to make a demand draft to whom? To the corporate debtor, and that demand draft, that is there something which is going to contain, that is first copy of invoice, second demand requiring payment of amount is actually involved, and that is default. Okay, and notice shall be in the prescribed manner. This is what the demand notice contain. Okay, so once this demand notice is received by the corporate debtor within a period of 10 days of receipt, ठीक है, within a period of 10 days of receipt, MCQ में आ सकता है, bring the notice to the operational creditor, have to give a reply. This was all about this section 8. ठीक है, whether there is some dispute was occurred, ठीक है, or they have actually paid the amount, the operational creditor have is not a genuine person, whatever. Okay, there would be some other reason also. Okay, so this should be quoted in the response of the demand draft. Okay, so this was all about the section 8. Let's go for section 9, the continuation of section 8, guys. Once application for CIRP processed by the operational creditor, filing of application before the educating authority, it's educating A, ठीक है, not E. Okay, initiating CIRP from expiry of date of delivery of notice, कौन सा वाला 10 days के बाद, हाँ जी. So in this case, when the operational creditor do not receive any of the amount from the corporate debtor, in that case the operational creditor can file the application to whom? To the educating authority. Yes. Then the CIRP process is going to initiate again. With that, the demand draft, there are some documents along with application which is to be submitted to A. What is that? Copy of invoice or the demand notice under section 8, right? Affidavit that no notice stating existence of the disputing received from the corporate debtor if there is, and then the copy of certificate from the financial institution. How they are going to prove that कि इन्होंने पैसे नहीं पे किए, हाँ, how they are going to prove that? So the copy of certificate from the financial institution should also be attested. Name of proposed CIRP नहीं IRP, ठीक है, interim resolution professional, which is resolution professional. They may be in future they would be appointed as IRP if there is no other pending proceeding is done against him, ठीक है, or any other proof which is actually specified by the board. So application may be accepted, same thing again, guys. You have to just remember one part, then it's going to apply for the other sections. Like in section 7 you have to remember, then it's going to apply in 9 and 10. Okay, so you have to remember these conditions. So again, the application is going to be accepted by A or rejected by A within 14 days. So when they are going to accept that, the A is going to accept the same thing. Application is complete for the CIRP. There is no payment of unpaid operational debt. Second, the notice for the payment to CD, corporate debtor, has delivered by OC. ठीक है, which is operational creditor here. No notice or disputes has been received by the operational creditor ठीक है, by whom, by the corporate debtor. Okay, and no disciplinary proceeding pending against the resolution professional proposed by the OC. Okay, इतनी बात समझ में आ गई? हाँ जी. So if everything is going great, then exactly the AE can accept the application, ठीक है, on the basis of documents and all, ठीक है. But with that the AE can reject if that is contravention to the conditions, ठीक है. सेम थिंग रेसिप्रोकेट हो गया तो द ए इज गोइंग टू रिजेक्ट दैट with the application for initiating CIRP is not complete, and same where the payment of the unpaid operational debtor and all, ठीक है. सेम थिंग अपोजिट कर देंगे तो the A is going to reject. Yes, before rejecting the application, AO shall give a notice to whom? To the operational creditor. Within 7 days they can rectify it. Let's go for section 10. Section 10 is about the initiation of the corporate insolvency resolution process by the corporate applicant. So whether it's going to be happen, yes, once the default commitment by the corporate debtor, corporate applicant may file the application to whom? To the adjudicating authority to initiate what? The corporate insolvency resolution process. Same thing है ना, same thing, सब कुछ same है, बहुत easy है ना. हाँ जी. So here what are the documents which is to be placed along with the application? Number first is going to be book of accounts and any other documents. Second, information which is related to resolution professional, ठीक है. हाँ जी, the name of resolution professional should be proposed here, and with that a resolution, special resolution should be passed, or a resolution should be passed. Special resolution passed by shareholder in case of it's a corporate debtor, ठीक है, and resolution passed by 3/4 of total number of partners in case of partners, ठीक है, firm वगैरह के केस में. Okay, so in this case that's going to be 3/4 of partners. Otherwise it's going to be special resolution in case of the shareholder. And the same thing again, the adjudicating authority are they going to accept or reject within 14 days. Okay, and the same thing, same thing, everything is same, ठीक है. Let's go for the section 11, which is important. Same question आया है. What is who is the person not entitled to make the application? Number first, the corporate debtor who is undergoing the CIRP process, the corporate insolvency resolution process, who is actually undergoing the through this process, cannot again appeal or cannot go for the application for CIRP. अब भैया तुम ऑलरेडी CIRP के प्रोसेस में हो, तुम कैसे जा सकते हो आगे दोबारा, ठीक है. सो इट्स यू कैन नॉट डू दिस. लेट्स गो फॉर द सेकेंड पार्ट विद the corporate debtor having completed CIRP 12 months preceding the date of making application. Just he have completed the 12 month, so you cannot go for if the corporate debtor. Third point says of the corporate debtor of the financial creditor have violated the terms, ठीक है, which was approved 12 months before the date of making of application for initiating the CIRP. So once this corporate debtor of financial creditor have violated any term just before 12 months of initiation of CIRP, again this person cannot be counted or cannot make the application. Okay, last says about the corporate debtor in which of the liquidation order has been made. So these are the point which you have to mark, guys, because it's important and it's gonna come as it is. Let's go for the section 12. What is going to be the time limit? Within 180 days this process should be completed. Extension more 90 days दे सकते हैं, but at last all over time period बोलूँ 330 is going to be the time period where the CIRP shall mandatory be completed within 330 days from initiate from the insolvency commencement date. Okay, so 180 days, 90, then 330. It's going to be, everything should be done within that 330 days. Let's go for section 7, 9 and 10. Whether withdrawal of application amounted under section 7, 9, 10. Yes. Now for this 90% of voting share of committee of creditor should be specified. If they are going to approve kitane percent, 90% of what? The COC, the committee of creditors. Otherwise withdrawal cannot be possible. Acha, do you remember we have just completed one question. Do you remember where the withdrawal was done in Rajamundry Electric Supply Corporation and versus Nageshwar Rao, where I already discussed about the case. And now where which chapter I'm talking about. ठीक है, केस स्टडी से आपको याद आना चाहिए कौन सा चैप्टर है, वेदर इट्स ऑपरेशन एंड मिसमैनेजमेंट और कॉम्प्रोमाइज एंड अरेंजमेंट और दी विच इज़ रिलेटेड टू रजिस्ट्रार वाला, ठीक है, इंस्पेक्शन वाला. सो इट्स रिलेटेड टू ऑपरेशन एंड हाई, सो इट्स रिलेटेड टू ऑपरेशन एंड मिसमैनेजमेंट. ओके, सो आपको पता है क्या अपन को रिलेट करना. इन दैट केस विड्रॉल वॉज नॉट पॉसिबल. हाई फैक्स, shout out नहीं, क्या? I'm unable to understand. Okay, so in that case withdrawal was not possible, right? Even though majority of member want to withdraw that the application, but in this case withdrawal is matlab shout out. What is shout out? दीजिए. What is shout out? I don't know. Shout out दीजिए, मुझे नहीं पता चल रहा आप क्या बोल रहे हो. Okay, so for this case 90% of COC shall give the approval, then only they can grant the withdrawal of application can be done. Let's go for section 13 which is declaration of memorandum and the chat में नाम बोलना. अच्छा, आपका नाम है फेक्स, आई गेस फेंस एडिट्स. ओके, हाय, हाउ आर यू, ऑल गुड, आप पढ़ते हैं राइट? हाँ जी. So let's go for the 13th section which is saying about the declaration of moratorium and public announcement. हाँ जी. So first of all the interim resolution professional should be appointed under section, this should be declared in section 13. Moratorium होना चाहिए, ठीक है. And then public announcement once the CIRP process is done, and third declaration of moratorium. Okay, so let's go for section 14 which is also important. On the insolvency commencement date the AA shall by order declare moratorium for the prohibition, so it won't be allowed the prohibition, so anything which was done like case and all, ठीक है, so that is going to be prohibited from the date of commencement of CIRP. It's all about the moratorium. Okay, so you have to read it guys. Let's go for the other part. Section 15 simply saying about the public announcement should be done once this part is done, where the name and address of the company, name of address of this the resolution professional who is appointed as IRP, and then last date of submission of claim and detail of everything, it should be mentioned there. Okay, let's go for section 16, an appointment and the tenure of IRP professional. As I told you, the name which was given by the financial creditor under section कौन सा था 7 है ना, and then the operational creditor कौन सा था section 9, और the corporate debtor कौन सा था 10. ठीक है. The person whose name was appointed as a resolution professional can be appointed as interim resolution professional, but only if there is no pending disciplinary proceedings are pending against him. Okay, so this is all about section 16. In case of financial creditor, the name financial creditor and the corporate debtor under section 10, you have to mention this guys. Okay, so everything, if there is nothing pending or disciplinary pending against him, the person would be appointed as what, the interim resolution professional. But what if there is something done wrong, matlab there is some pendency, disciplinary pendency against him, in that case the A will refer board. Okay, and board will give the name of the IRP, the RP, let me say, ठीक है, within 10 days. Okay, where the A have approached the board. Okay, and that name is going to be finalized as the interim resolution professional only if there is no again disciplinary proceeding are against that person. इतनी बात समझ में आ गई? हाँ जी, it's very easy guys. Okay, लेट्स गो फॉर दी लास्ट नहीं है, इसमें बहुत सारे सेक्शंस हैं. सेक्शन 21 सेज अबाउट द कमिटी ऑफ क्रेडिटर वेयर 51% ऑफ वोटिंग शेयर ऑफ द financial creditor should be taken. Let's go for the section 22 where the appointment of resolution professional. Okay, within that first meeting of committee of creditor shall be held within the constitution of committee of creditor. Once the committee of constitution of committee of creditor is formed, within that 7 days the meeting should be done, otherwise okay, ये MCQ के फॉर्म में आया है क्वेश्चन, so mark it. So interface meeting of the committee of creditor may by major vote not less than 66% of voting share of the financial creditor resolve to what the appoint interim resolution professional as a resolution professional, जो कि हम decide कर चुके हैं, or if they want to replace any of the interim resolution professional, that should be again done by this, but what with the 66% of the voting share of the financial creditor. So MCQ आ सकता है. Okay, what if they want to appoint that resolution professional, interim resolution professional, they want to replace them, then again the same process, the adjudicating authority, either they would recommend any name to the adjudicating authority, and adjudicating authority will go to the give the order or application to the board, and board will either accept it, or board will give any of name, give the suggestion of name of any resolution professional, and that resolution professional is going to be appointed as interim resolution professional only if no proceeding is pending, any disciplinary proceeding is pending against him. Okay, let's go for section 23. We're saying about the resolution professional to conduct corporate insolvency process. Resolution professional shall conduct CIRP to manage operations of the CD, which is corporate debtor. Here the resolution RI shall exercise all the power and perform duties as vested as IRP. And what is this IRP? Interim resolution professional. Okay, so I'm going to say it in short. Shall provide all the information, shall provide all the documents, shall provide all the documents which is pertaining to CD, corporate debtor, to resolution professional. Okay, where the COC resolve the IRP and constantly a CP is appointed by AA. Let's go for the section 24, which is meeting of creditor in person. Okay, this could be done in electronic form or in a person, in any way. Okay, so all the meeting of COC, the committee of creditor, shall conducted by whom? By the resolution professional. So the resolution professional shall give notice to all the members of the COC. Okay, committee of creditors, with with whom who is going to be counted as the member of COC, the member of suspended BOD, board of director of the operational creditor, operation person, or the operational creditor. The meeting of COC shall conducted in such a manner as may be specified. So this part is important, guys. Section 24 is important. Let's go for the section 25, which is the duties of resolution professional. What is now the duty of resolution professional? To preserve the asset of the company, of the corporate debtor. Let's use a word which is corporate debtor. Like second, to protect the asset of the corporate debtor. So RP, the resolution professional, shall undertake the following action for the purpose of the preserve of asset and to protect of asset of whom? Of the corporate debtor. Now here they can appoint any of the auditor, accountant, legal, or any other professional as may be specified by board, and they have to maintain the list of claim and attend all the meeting of the COC and prepare the information memorandum with that, and invite prospective resolution applicant and preserve that resolution plan at the meeting of COC, and such other action which is specified by board. So guys, section 24 is also important, section 25 is also important. Let's go for section 27, where the replacement of resolution professional by COC is done. Yes, पर replacement कितना percentage होना चाहिए? 66% of voting share. Yes, the name same thing is written here. The name of proposed RV is going to be proposed to whom? To AA, and AA will forward the name of RP to board, and board may confirm or board may recommend any name of any other person as a resolution professional. What is going to be 28 section saying? This is again important. Approval of COC for the certain action, that is the resolution process shall not take any of the following action without prior approval of COC. So there are some restriction also. So for this they have to take prior approval from the COC. Okay, resolution professional. Okay, and what is that? To raise any interim finance which is excess, which is decided by COC earlier. If they want to raise excess of that, then they have to take the prior approval from the COC. To create any security asset, change in capital structure of CD, record or change in ownership, undertake any related party transaction, amend any constitution document, delegate its authority, okay, and make change in management of CD, and make change in appointment and all. Okay, so you just have to read out, and it's important also. Okay, let's go for 29 section, preparation of information memorandum. Here the RP shall prepare information memorandum specified by whom? Specified by board. Yes, what are the duties which RP to produce information to resolution applicant which comply with the provision of law, which protect the intellectual property, to not to share any of the relevant information with the third party. Professionalism नहीं होता ये जनाब, code of conduct नहीं होता जनाब. Let's go for the important question 29A, which is सीधी question आ चुका है इस part में से. Person is not eligible to be resolution applicant when his in undischarged insolvent, when he is willful defaulter as per RBI, okay, which is as per the guidelines of RBI under Banking Regulation Act 1949, with that has been convicted in any of offence. Acha, if we are unable to remember the offence for the 2 year or more for 12th schedule or for the 7 year or any other law, so just itna yaad kar lo, has been convicted for any offence punishable with the imprisonment. Okay, so first was undischarged insolvent, second willful defaulter which was as per RBI specified guidelines, and third have committed or convicted by any offence punishable with imprisonment. Okay, and fourth disqualified by as a director, fifth prohibited by RBI. So for this, a person not eligible to be resolution applicant under section 29A, which is important, again undischarged insolvent, willful defaulter, okay, and then it was like convicted of with imprisonment, and for director and SEBI के हिसाब से भी गलत है वो बंदा. Okay, and has been promoter of control of CD corporate debtor in which preferential transaction have done, or undertaken transaction is done, or extortion credit transaction is done, or fraudulent transaction is done. ठीक है, so this person was a promoter or control of corporate debtor and he was involved in such things. ठीक है, fraudulent activity में involved था ये बंदा. Okay, and he has executed a direct guarantee in favor of creditor in respect of CD at time of submission of resolution plan as an account or corporate debtor under management or control of a person of such promoter. ठीक है, so guys this part is important, you have to mark it down. ठीक है, and ये ज़्यादातर आता ही आता है क्वेश्चन. ठीक है, लेट्स गो फॉर द सेक्शन 30 where the submission of resolution plan is to be done, where the resolution applicant shall submit the resolution plan to whom? To the resolution professional. Okay, and there are some things which is specified by board which is to be mentioned in the resolution plan. Okay, so same thing, it is going to be accepted and it's going to be applied for all of the corporate debtor, employee, members, creditors, CG, SG and the local authority, and even here the AA can reject that plan also. Okay, let's go for the important part, guys. I am going for section 35. You have to remember the power and duties of liquidator with this, yes, let me read it because it's important little bit. है ना? What is the power of duties of liquidator? To verify claim of all the creditors, to take into custody or court of property asset of the corporate debtor, to evaluate the asset and property of corporate debtor, to carry on business of the corporate debtor, to sell the immovable property and movable property of the corporate debtor once the liquidation is going to happen. ठीक है, or to take out in sufficient name, letter and administration to any deceased contributory, to obtain professional assistance from any person, to investigate in affair of the company of corporate debtor, to take any such actions, step or sign, execute and verify any paper, deed, receipt, document, or to perform all other functions which may be specified. So these are the power once the liquidation is happened. So liquidator is going to be appoint, and these are the duties and power which is done by liquidator. Let's go for the last point, I guess, last section, which is distribution of asset under section 53. Okay, once the proceed from the sale of liquidation happens, so in order they should be happen. What is the order? I'm going to tell you one by one that it should be distributed in following order of the priority at within such period and such manner as may be specified. Number 4, the insolvency resolution process cost or liquidation paid in full. Okay, the following debt which shall rank equally between women's due for period of 24-month preceding liquidation commencement day, the workmen due for period of 24-month preceding liquidation is going to be taken, or that for the secured creditor. Okay, with what? Relinquishment security. So number 4 key process liquidation cost. ठीक है, these are the things which the payment once the sale proceed from the liquidation happen. So the sequence is going to be there which the company have to follow. The cost which we of the preceding cost of the liquidation is going to be first here, and it should be clear of. Second is going to be the workman due for the 24 month before the liquidation happen. Third, उसी के अंदर सेकेंड पॉइंट क्या है, secured creditor with the relinquishment security. Third is going to the wages and any unpaid dues an employee other than workmen for a period of 12 months. Yes. Fourth is going to the financial debt which is owned by the unsecured creditor. Fifth, any other due amount which is due to central government, local, state or any other person, ठीक है, government से related. And in this secured creditors for any amount which is unpaid following the movement of security, and the remaining, if there is amount, then remaining debt and dues should be cleared off, then preference share, then the equity shares at last. So this was all about this part. So you have to remember the sequence कि किसको पहले पे करेंगे guys. Okay, so you have to go for this also guys. Okay, so these were the important part I have already mentioned है ना. You just have to remember something because सीधे सीधे questions आते हैं इसमें से ज़्यादातर, जो कि मैं बता चुकी हूँ. What are the resolution professional process क्या हो सकते हैं, है ना. COC के क्या बोलते हैं उसको, मीटिंग कब कंडक्ट होगा, हाँ जी, एंड लाइक दैट. ठीक है, ड्यूटीज़ ऑफ रेजोल्यूशन प्रोफेशनल क्या है, रिप्लेसमेंट ऑफ रेजोल्यूशन प्रोफेशनल कैन बी डन बाय COC, व्हाट आर द प्रोसेस. तो सिंपल क्वेश्चन आते हैं ज़्यादातर. ओके, और दी फाइनेंशियल क्रेडिटर केस, लाइक फाइनेंशियल क्रेडिटर का दे दिया एंड यू हैव टू टेल वेदर दे कैन डू दिस और इनिशिएट द एप्लीकेशन फॉर दी CIRP और नॉट. लेट्स गो फॉर वन few questions guys. मैं just reading लगाऊंगी and you have to do it by your own. Okay, hope so you guys are having a scanner with you. Yes, so let me tell you the important thing. Okay, let's go for the page number is 13.226. It's as per December 24 scanner. Okay, so what are the applicability of insolvency and bankruptcy code 2016? किस पे हो सकता है guys? कंपनी पे हो सकता है, yes. Special act, a company which is formed under any special act, LLP or any body corporate which is notified by CG or the partnership. Okay, this is the normal thing. Person who are not entitled for initiating the CIRP, the insolvency resolution process, as we all know. ठीक है, so I have already marked it as important. Okay, and there is one more question which is of okay, there is one more question of replacement which is related to replacement of the resolution professional by the COC. Again, do you remember? हाँ जी, as per section कौन सा था? Remember 27 था क्या? हाँ जी. So as per COC that could be done. कितना majority percentage should be there, है ना. Next is going to be the June 2018 question, page number 13.230, where initiation of CIRP process by the financial creditor is done. Remember, financial creditor can be can file the application, right, and there are some process which you have to follow, right, either by himself or jointly, or if he's going for jointly, again on behalf of the financial creditor or like joint financial creditor. Okay, so this was all about this part guys. And further क्या होगा, यही कुछ आएगा, then उसके बाद क्या जाएगा लास्ट में, against whom, corporate debtor. ठीक है, AO can actually accept or reject that application within 14 days, है ना. With that the application document should be sent. Okay, this was all about this part because these are the process and you have to keep this process in your mind, then only you can answer the questions, right. Let's go for the last part. I want to read this question. Okay, so let's go for December 2000. I'm just going to take your 5 minutes guys, not more than that. Okay, so December 2022 question number 13.234. Mr. Emerson, operational creditor, file an application with the adjudicating authority to initiate the corporate insolvency resolution process and against TR Limited. The application was accepted on 10th of July 2022. NCLT is Delhi appointed MS to act an interim resolution professional to TR Limited. After appointment, MSVS issued the public announcement on 12th July of initiation of CIRP process and called for the submission of claim on 20th July 2020. The committee of creditor was constituted by Mr. VS. Therefore, MS want to withdraw the application. So whether this can be done, withdrawing of application can be done or not, is a good question, right? Under section 12A of the Insolvency Bankruptcy Code, and stating that the COC have already been constituted. Okay, so let's go for the case here. Number 4 is MS right to deny Mr. MS to file withdrawal of application within NCLT Delhi. Explain in detail. Number four's answer is that under section 12A of the Insolvency Bankruptcy Code 2016, read with the regulation 30A of IBBI regulation 2016, the EO may allow the withdrawal. Yes, we already discussed this, but there is some condition ना कितने percentage होना चाहिए था, है ना? Okay. Application admitted under section 7 or section 9 or 10 on application made by the applicant with the approval of 90% of voting share in the COC, then only withdrawal is going to happen. So either this question may come in form of MCQ, what is the percentage of COC if they want to withdraw, right, application. So approval of COC is required here 90%, okay, in such a manner which is specified. So the application can be withdrawn if approval of 90% voting share of the COC is obtained. Okay ji, हाँ जी. So let's go for the second. Would your answer be different in case of COC is not constituted? Again, before constitution of COC, the applicant may make application for withdrawing to adjudicating authority if COC is not formed yet. So first of all, the application should made to AO through whom the interim resolution professional, right. The resolution professional shall submit such withdrawal application to AO on behalf of applicant within 3 days of receipt of the request. So the final approval of such withdrawal shall be by way of pass of AA. If the committee of creditors is not constituted, MS shall apply to executing authority through the interim resolution professional for their withdrawal. Simple बात है. So if there is constitution of COC, मतलब which is committee of creditor, तब तो ठीक है. The creditors can directly approach the COC, right? If there is no constitution of COC, in that case, what is going to be happen? Then the application can be formed, can be applied to executing authority, but before that they have to, the application would be only done through the interim resolution professional. Okay, okay. इतनी बात भी मुझे समझ में आ चुकी है. So if COC is not constituted, MS shall apply through the AA through the interim resolution professional, and this is going to be the last point. Therefore, the answer will not differ if Mr. VS cannot deny Mr. MS to file withdrawal of application with NCLT Delhi. Okay, who is the authority to pass the final order of withdrawal application, guys? Educating authority है ना, हाँ जी. So which is NCLT basically. The final approval of such withdrawal shall be by way of order of pass of educating authority NCLT Delhi. So that was all about this section, guys. मैंने थोड़ा ज़्यादा टाइम ले लिया, बट कोई बात नहीं ना, कम से कम अपन 4 चैप्टर कंप्लीट कर चुके हैं मेजर, एंड विच इज़ ऑफ SARFAESI and RBI Banking Regulation Act 1949 with the Insolvency and Bankruptcy Code of 2016, है ना. So hope so guys, it was fruitful. If it was, what you have to do, hit the like button, subscribe my channel, है ना, and share this video with all your CMA final students. Okay, तब तक के लिए क्या करना, पढ़ते रहना, मस्त रहना, खुश रहना guys. Okay, so today guys, है ना, we'll meet tomorrow and I'll share all of the information which I'm going to teach you tomorrow in my Telegram channel. If you have no Telegram, my Telegram's channel link, so you'll get it in my description, my bio's description. Okay, you can easily access into my Telegram channel, and in that Telegram channel you'll get all of the handmade notes by me. Okay, so keep this with you, download it. Okay, till then we'll meet guys, bye, toodles.